Welcome to CREPN Radio for influential commercial real estate professionals who work with investors, buyers, and sellers of commercial real estate coast to coast. Whether you're an investor, broker, lender, property manager, attorney, or accountant, we're here to learn from the experts.
To Commercial Real Estate Pro Network. My name is J. Darren Gross. This is Commercial Real Estate Pro Network's CREPN Radio. I'm a commercial insurance broker and a real estate investor. And a long time ago, I recognized the importance of learning all the ins and outs, ups and downs of commercial real estate in order to better help my clients. Commercial Real Estate Pro Network and CREPN Radio are my effort to have and share conversations with experts on topics of interest to investors and professionals dealing in commercial real estate. And the goal of this is to help those in commercial real estate. You can find us by Googling Commercial Real Estate Pro Network. You can find us on Facebook, YouTube, LinkedIn, and on our Twitter account at CRE Pro Network. And coming soon, we'll have our website up. It's commercialrealestatepronetwork.com. How you can help if you like what you hear and you have a network or friends or you have a Facebook account or a LinkedIn account, comment, post, like, and share, and let people know that we're out here. Today, our topic is construction law. And if you know anything about construction, you know it's dangerous, it's expensive, and it's central to the United States economy. If you're going to borrow money, whether it be to build a home or a tower, banks are all going to require that you have insurance. And as I mentioned, I'm a commercial insurance broker and have been since 1990. And over that 25 years, one of the areas of most dynamic change has been construction and the way insurance has been tested and the way it's been endorsed and the pricing and the availability and all that. And so today I couldn't be more excited and delighted to have our guest, Kevin Connolly. Kevin is a graduate of Fordham University School of Law. He began his real estate lawyer as a real estate lawyer at the firm of Stroock Stroock Lavan, where he became the principal in charge of construction law. He recognized early on that construction and insurance have a strong connection, and he recognized that just as we coordinate all the construction documents that go into a contract, it's also critical that we coordinate the terms of the contract with the insurance coverage. He recognized that a lot of lawyers are notorious for cooking up insurance requirements that have no relation to the insurance market, and that many times the lawyers' forms are out of date, and often there's no effort made to ensure that the insurance program can work with the contract. Kevin's an honorary graduate of the United States Military Academy. He's a friend at West Point. He's also recognized by American Lawyer Media New York Law Journal as a top construction lawyer. He's a faculty member practicing Law Institute, and he's a leading expert on New York's complex lien law. I'd like to welcome Kevin to the program. Kevin, are you there?
I am here indeed. Thanks, Darren. Yeah, as you say, insurance is no surprise to anybody involved in construction. The surprise is, or maybe it's not a surprise, that the insurance often doesn't work the way it's supposed to. Now, part of the problem, insurance more than I am, can be related to some insurance companies, and we all know which ones I'm talking about, the companies that would delay, deny, and defend until the cows come home. Even the claims that are well-founded and properly presented are turned down because that's the way they do business. But another part of the problem is that sometimes the insurance isn't worked in correctly with the contracts. The lesson that the construction industry learned some years ago is that when the different designers, the architect and the engineers, sit down at the designing boards, if you don't force them to coordinate their work, they all end up trying to use the exact same 4x4 square to run all the utilities, all the electric, all the water, all the computer. Of course, not enough space. And the task of making sure that each person has his section to work on and they don't step on each other is called coordination. Now, that part of coordination is pretty well known. But the problem is that the other side of coordination, coordinating the documents the lawyers and everybody else produce, sometimes isn't quite carried out correctly. And that's one of the things that I'm going to try and emphasize today is the importance of coordination. Now, one of the most common variations we see when it comes time to go get insurance is that some contractors have their own relationship with the market, and they go and get the insurance. And that's fine and dandy. It may, in fact, be economical. But if the lawyers don't prick up their ears and coordinate the documents, you end up with a situation where the materials are delivered to the site and they belong to the owner. That's the way the contracts read. But the insurance says, remember, the contractor bought the insurance, is that stuff is the property of someone other than the first name insured, owner's property. And therefore, surprise, it's only covered for $5,000. Those kinds of losses, of course, can ruin your day. And it's a matter of coordinating to make sure that if, in fact, the contractor buys the insurance, that you change the documents to make sure the insurance coverage will work. Well, that's part of the job that sometimes is missed. Now, you, as an owner of a construction project, should understand your coverage. You have to get it. You certainly pay enough for it. And you, as the owner, have the most incentive to prevent these kinds of mistakes from hitting your bottom line. Insurance can help. Now, it's important to keep in mind that there are two basic flavors of insurance in this world, first party and third party. First party insurance pays you for your losses. It's like when you have a car. If your car is lost or stolen, your collision and comprehensive insurance will pay you for the car. This is first party insurance. First party insurance will pay you for your loss regardless of fault, so long as you didn't do it deliberately. Intentional acts are in a different category altogether. They can't be insured. But the idea behind first-party insurance is even if you were careless, you get paid for your loss. Third-party insurance pays someone else. They pay the losses that you are legally liable for. And the idea is that if you bought the insurance and it's triggered by the occurrence, the insurance company will step up and pay the damages. And just as important, they will pay the attorneys and private detectives and doctors who investigate and adjust the claim. Even for a small claim, even for a bogus claim, those costs are still covered, which is why we say that liability insurance is also litigation insurance because it covers you against those expenses. Now, coming back to the property insurance first, because frankly, in a construction project, the property insurance is what we call the bedrock of your whole risk management program. You're protecting your stuff. This is the basis for the whole project. You would be doing the project, you didn't see a benefit in doing it. Well, the first-party property insurance is there to pay the cost of reconstructing the building if it's damaged by a loss, by a casualty loss. And keep in mind that these policies are written so that they will pay the value of covered property, defined term, at the site set forth in the policy that is caused by or results from a covered cause of loss. And we could spend weeks talking about that last clause there. But keep in mind is that insurance policies on property are written to either say, we cover all risks. Well, all risks. We cover everything that's not excluded in this policy. We call that an open peril because it covers everything unless it's cut out, like war. And then there are named peril policies, which only cover the risks that are named in the policy. And that goes back to 300 years ago when insurance was first written to cover properties against fire, and fire only. They weren't covered against lightning. So if your building was struck by lightning and it burned to the ground, the joke was, well, the insurance company will pay for the fire that resulted from the lightning strike as long as you can prove what was done by the fire and what was done by the lightning, which is kind of difficult when the building is a smoking wreck. The idea behind these named peril policies is they do not pay unless the loss was caused by one of the perils that's named in the policy. Now, 90% of the insurance in this world is written on the open peril, something called all risks or special risks. The point is, that's the kind of coverage you want, because if you don't have it, first of all, you don't have as much coverage. There are kinds of mayhem out there that are going to not be covered by your insurance if you have a named peril policy. That's the whole reason for getting named peril is It covers less. It's less expensive. It's also not as good. The vast majority of construction insurance is also written to cover all risks, and therein lies some complications that insurance people like to talk about for weeks on end, having to do with the nature of marine insurance as opposed to commercial property insurance. And we'll talk a bit about that in a minute. Here's the thing. The property insurance for construction, it's called builder's risk insurance. It will pay the cost of repairing or replacing the property that is damaged as long as it's covered cause of loss. And in this world, there are two basic flavors of builder's risk insurance. Some policies are written under a rubric we call commercial property insurance, and others are written as inland marine. Now, I know a lot of people, their eyes glaze over when I mention the word inland marine. Don't worry about it. Get over it. Inland marine is just a kind of property insurance that attaches to things that move around or that change from day to day. 200 years ago, commercial property insurance was taking hold, but it refused to touch buildings under construction because they changed. And commercial property insurance is based on insuring things that are stable, that don't change from day to day. Ultimately, we were able to convince, the industry was able to convince these marine insurance companies to extend their coverage from just docks and warehouses on shore into all sorts of buildings under construction, because the idea is that a building under construction is, we say, an instrumentality of commerce. It's not a finished property. It's something that you're doing in order to create this property. And actually, there's a very great insight there, because the way buildings are built, they have been in the West at least for hundreds of years, is first, build a factory. Then, use the factory to build the building. Then, tear down the factory and leave the building. And because of this approach how these things are done, marine insurance companies were quite prepared to take these risks and cover these builders' risks. And only in the last 50 years have commercial property insurance companies stepped into the breach and also provided some coverage for buildings under construction. But there are some differences between the two kinds of coverage, and we'll see them as we talk a little further. Another important thing about property insurance is you have to declare a limit of liability. Now, this relates to, for instance, insuring your home. For how much money? Well, ideally, enough to rebuild the house. The same thing applies to a building under construction. In addition, though, to the hard cost, the nuts and bolts and bricks and mortar, there are also soft costs. For building under construction, if you have a property casualty loss, you're going to probably incur additional fees for an architect. Delayed completion is going to cost you interest on your loans, extra real estate taxes. All these soft costs can be covered by your builder's risk insurance, provided you're on an inland marine form. If you're on a commercial property form, which most brokers will write for you unless you demand inland marine, you might not have coverage at all for soft costs, or coverage you have might not be so good. So, inland marine, in general, is superior to commercial property. However, you cannot get inland marine insurance on a building unless it is a new building. You're building out of the ground. If you have an existing building and remodeling it or repurposing it or anything else along those lines, because the building itself is already complete, it is a violation of law in all 50 states to write the insurance as inland marine. You have to go to commercial property, and that's the reason why there still is a commercial property market for builder's risk, is because repurposing, renovation, remodeling, those are all written as commercial property because you're not coming right out of bare ground to build a whole new building.
Well, an actual violation of law, huh?
Yes, it's called the Nationwide Marine Insurance Definition. It's a list of about 20 different lines of insurance. It was agreed years ago between the property insurance companies and the marine insurance companies to come to some kind of peace, because left to their own devices, the inland marine insurance companies would have taken everything. Anybody who can put their insurance into inland marine as opposed to commercial property will generally do so because the coverage is so much better. It's broader. There are fewer exclusions. For example, construction. If your insurance is written on the commercial property form of insurance, you do not have coverage for collapse unless. Now, of course, during construction is the time when the building is most likely to fall down because it's not finished being built. And if you don't have a special collapse during construction endorsement in your policy, then you have no coverage. Now, a colleague from years ago attacked me for suggesting that you have no coverage. And I said, well, that's the way the policy is written. She insisted that they can make an argue that the policy is ambiguous because one form, the causes of loss form, lists collapse as a covered cause of loss, whereas there's a very clause back in the insurance policy itself, very small print, that says that thing has been taken out per construction project. Okay? I mean, I am not so confident. I mean, I would certainly make the argument if I had to in order to win the case, but I had a whole lot of confidence because it's wrong. What you could have done, for pity's sake, is either get an inland marine insurance, which would cover the collapse, or get the endorsement. Now, that endorsement sometimes is a real bucket of ice water in your face because if you have entered into standard forms of contract with your design team and you have agreed not to sue the architect or structural engineer for losses caused by their negligence in the design of the project, then you are hit with a 500% upcharge on the charge for the collapse coverage. And that, let me tell you, can be a major shock, particularly since the collapse coverage is fairly expensive in the first place. Even better is the fact that you might not know about this until after the project closes out, because the insurance company can always come back, or sometimes for years after the project closes out, and audit the premium. You know, they may say that you actually spent an extra $1 million on this, you owe us extra premium. Or, as in this case, is extra money involved. Plain and simple, if you don't disclose to the insurance company that you have waived the subrogation, they can still come back. They'll charge you the basic rate, but they can come back years later, audit you, and upcharge you. Therefore, it's important to keep in mind how your contracts are written. And again, this reemphasizes how important it is to coordinate how your contracts are written. Did you waive subrogation against the architect or the structural engineer? And how is the insurance fit? Because it can penalize you lethally if you don't take care of that. Now, when time comes to buy insurance, the first question.
Kevin,
yes.
I just want to ask you real quick. So you're talking about you waive your rights against the architect, engineer. So is a standard waiver of subrogation, is that going to null and void that? I mean, is that what we're talking about here? That you've
if you went in and signed the industry standard AIA contract of architect contract, or the standard EJCDC form of engineer contract, both of these standard forms contain a clause that says that you will not sue the architect or engineer for losses caused to the extent that they were covered by property insurance, your property insurance. And it's sometimes called a waiver of subrogation. The idea is to prevent the insurance company from mounting a subrogation claim against the architect.
The professionals.
Subrogation can be very complicated. The idea is that when an insurance company pays a claim, like a property claim, they step into your shoes. So the building falls down. Obviously, the architect or structural engineer did something wrong because buildings are not supposed to fall down during construction. Therefore, the insurance company pays off the claim, remove the debris, clear the site, redo the construction, and then they would like very much to turn around and sue the architect and engineer, and frankly, anybody else they can reach for the loss they've just paid out. Now, if the contract contained a clause that says that I waive the right to sue the architect and engineer to the extent I have property insurance, that's called a waiver of subrogation, and yet that triggers a great increase in your premium. And these clauses sometimes come in without you ever knowing about it, because if you have a lawyer prepare these documents, you might not sit down and spend the 50 hours of time needed to read through the whole package of documents. And as a contractor or the architect or the engineer prepares documents, you can be sure they contain these clauses because they help the architect's bottom line. So it's important to make sure you know what's in the contract and how things are holding together. Now, when you go to a broker or agent to buy insurance, one of the first questions going to be asked is how much. Your insurance comes with a limit. There's a number that says the insurance company is not going to pay more than the limit for a loss. And how these things work out can be very complicated and surprising. In the case of property insurance, the limit of liability applies to each occurrence that causes a loss. Now, that's why back when the World Trade Center was destroyed by the attack, there was a long, hard-fought case over whether it was one terrorist organization, therefore one occurrence, or 2 airplanes and therefore 2 occurrences. Because Larry Silverstein had written insurance on the World Trade Center for just $1 billion with a B. If he had prevailed on the claim that there were 2 occurrences because there were 2 airplanes, then he would have been covered for $2 billion because each occurrence in a property policy is covered for the full limit of liability. As it turned out, of course, the cost of clearing the property of the World Trade Center and rebuilding is far more than even $2 billion. But there are some high-stakes issues involved here, and some people don't realize that a property policy pays up to the full limit for each occurrence. Of course, theoretically, you insure the property for its full value, and the World Trade Center is probably a bad example because it was so complicated, so much value. For your ordinary construction project, the insurance company is going to say you're going to buy insurance for the full budget amount. And a lot of people say, well, I'll buy it for 80% or 90%. But in construction, there's what amounts to a 100% co-insurance clause. Co-insurance is another tricky thing that really comes in to penalize you if you play a game with your limits. Here's how it works. You own a property. You recognize that the vast majority of claims on this property are not going to be total losses. Not going to take down the entire building, pay off the full debt. No. It's going to be you had an overflow in the HVAC system. You had a fire on the 5th floor. You have these small partial losses. You don't need $100 million of insurance on a $100 million project. You can probably get by with $20 million. How many claims are going to bust $20 million? Most of them are. So you can save a lot of money and, frankly, stick it to the insurance company by buying less insurance. That's where co-insurance comes into play. Co-insurance clause says, nice try, but because you underinsured your building, we're going to prorate your payment. So you have a partial loss here. You have a $100,000 loss on your $1 million building. Okay, but you only insured the building for half of its value. So even though you had a $100,000 loss, we're going to pay you about 50% because you underinsured the building by 50%. And that's how co-insurance comes into play. Bear in mind that you can always try and get the insurance company to waive out of co-insurance. You can do it, it's a good idea, by giving what's called an agreed amount endorsement. A lot of banks are very enamored of agreed amount endorsement, although sometimes they don't understand. I think the banks think agreed amount endorsement means that the insurance company agrees to pay X dollars for each item that's destroyed, but it's not what it means. All that the agreed amount endorsement says is that policyholder, as long as you maintain this amount of insurance, we will not raise co-insurance to reduce the amount of insurance we pay out. And that's all it means. So that's the agreement. If you don't satisfy co-insurance, you can be surprised because you don't get enough money. And if the number one surprise of insurance is you're expecting X dollars from the insurance and you don't get X dollars, and co-insurance is one of the things that can really reap out and hurt you there. Another question that leads us, although not so much in construction, but not necessarily at all, because we're talking about insurance and coverage, is the difference between replacement cost and actual cash value. The insurance policy says that we, the insurance company, will pay the value of covered property that is destroyed or damaged by covered cause of loss. The value is based either on what it costs to get it new or its actual cash value. And actual cash value is the same as the replacement cost minus depreciation. And in that phrase is a world of fight. The property, back during one of the last major storms, that was located in Coney Island, was 65 years old. And it hadn't really been reconstructed in a while. And the building was heavily damaged. The insurance company insisted that this building, which had a rent roll of $30 million, was only worth $7 million. So they tendered a check for $7 million. Said, we're done. We're not going to pay anymore. And that was because the property was insured for its actual cash value. Now, in the case of construction, it shouldn't make a difference because everything should be new. But look at your contract, look at your policies, and try and line them up because sometimes you can get it to fight properties less than a year old. Construction project going on for a year. Actually, project going on for 5 years. Oh, brand new construction is subject to depreciation. Can get into a world of fights and hurt, and for no good reason. Just go and get the replacement cost which should not cost you extra money for the building. It should be actually the same price. Negotiate. You can make it happen. But replacement cost is always superior. There's one less thing you have to prove. Now, another area of surprise that comes when you don't properly coordinate things has to do with how property becomes covered. Materials and equipment is delivered to the site. Under your standard builder's risk insurance, these things are not covered until they are put down at the site. So you could have a modular construction with pieces coming cross country by rail. It's a truck, falls off the train, destroyed. It's not covered by your builder's risk insurance unless you have special risk insurance. But for the most part, builder's risk insurance doesn't cover the stuff until it arrives at the site. So if there's a loss during transit, or if the stuff is put into a warehouse because there's no place to put it when it gets to the site, it's not covered unless you get special insurance. P.S. It happens to be a form of inland marine insurance called an installation or transit floater. But the point is, if you don't have that coverage, you may well have a gap. And just like they say on the London Tube, mind the gap, because the gap can hurt you bad.
Yeah, no kidding. Warehouse full of materials to be installed, and the warehouse burns down, and your stuff's in it. You're out of luck.
Right, because
unless you got the endorsed properly.
Now the warehouseman has an enhanced liability. He basically, it's not an absolute liability, but a common carrier or warehouseman is subject to what we call the highest duty of care. Now, what the highest duty of care means essentially is, as a practical matter, if he loses the materials, he's going to pay for it. But there can be a fight on the way because there are certain things that could excuse the warehouseman from paying for the loss. For example, if there's an act of a hostile power, a war act, not liable. And if an act is committed that might have been the act of a foreign power, the insurance company is not going to pay until they figure out what went wrong. So it's always better if you can have your own first-party insurance that will pay you for the loss, regardless of fault, regardless of anything else. It's your stuff. It got destroyed. You get paid for it. Provided it was caused by, we say, a covered cause of loss. This is why the all-risk or special form insurance is so much better than the so-called broad form, because the so-called broad form actually doesn't cover a lot of things. It covers the losses it covers fire and lightning, and then losses that we call WC shader, which is wind, commotion, including commotion accompanying with a civil disorder, smoke, hail, aircraft, vehicles, explosions, and riots. WC shader. And not much else. So you get fire and you get lightning and these occurrences. Oh, and also malicious mischief. But there are thousands of things else that can go wrong. For example, unless your insurance is specially written to cover it, the weight of ice and snow on your roof that causes the collapse isn't covered. It's like so important to get the broadest form of coverage you can get. Doesn't cost that much more. 90% of people buy the all-risk type insurance, and it's reason for that because it is superior. I mean, that's the basis of property insurance at this point. The vast majority of insurance for property is written on a basic form called the Building and Personal Property Form, a well-known form. It's a good form, but you always have to read the policy. You know, it's a contract. It's written down. Very important to sit down and read through it, and you'd be surprised what you can find. There are sometimes riders and modifiers that are put in that you look at it and you say, wait a minute, with this in here, my insurance is worthless. And if you don't object, if you let it slide, in many places, the fact you accept the policy means you can't object. You're stuck. And there you go. So that's the whole idea behind first-party property insurance. You know, there are a lot more things that go into this kind of insurance if you have a completed building, but, you know, maybe we'll defer those for another day. For construction, this is it. It's builder's risk insurance, and keep an eye on the possible need to expand it through these installation floaters, and that will cover 99% of your problems on the property side. On third-party insurance, though, the fact is that construction is dangerous. There's personal injuries, there's property damage. Statistically speaking, I saw a study a while ago that said, well, yes, while people in combat get blown up and hurt worse, and, you know, they're being shot at by people in anger, the fact is that in the construction industry, you're more likely to sustain a disabling injury than you are as an infantryman in a combat zone. And that should remind us that what we're doing is dangerous, and to make sure we have coverage that covers our liability to third parties for personal injury and also property damage. And just as important, have something out there to pay for legal bills. Liability insurance also comes with limits of insurance, just like property, except they're different. They're different because with liability insurance, you always have at least two limits. The first limit applies per occurrence. The second limit applies in the aggregate. So if you buy insurance that pays $1 million per occurrence and $2 million in the aggregate, this means that no matter how many claims you receive in the course of a year, once the payout for all those claims hits $2 million, the insurance company stops paying. Oops. These limit serve to limit liability. There?
No, I was just going to say the thing, too, that people don't always understand is when if the company receives a claim and they reserve limits, they haven't paid anything out, but they think they might pay. You can wipe out an occurrence limit right there, just based on a reserve, when they reserve a claim based on what they think they might pay.
Yeah, exactly, which means that, and of course, the other kicker is that once the insurance company has used up its limit of liability, they also stop paying for the defense. Now, it also pays to take a close look at the insurance, not just your insurance, but your contractor's insurance, because especially in the construction industry, a lot of people have policies that provide that the legal expenses and cost of investigation will use up the insurance. These payments are inside the limits. They use up your insurance limit. Other policies, these things are outside the limits, so no matter how much is involved on those expenses, they don't use up your insurance. P.S. You want these expenses to be paid outside the limits, because otherwise you get a situation of having a big claim, you don't get a settlement, you're coming down to the day of trial. You go into the courthouse to pick your jury, and the insurance company shows up at the courthouse and says, "Oh, you're on your own. You've used up all the insurance. Good luck. Bye." It happens. Right. Now, of course, 9 times out of 10, the insurance company is playing a game. In fact, they're still on the hook. But the claim is often made that the policy has been exhausted by insurance paying for legal investigation expenses that are inside the limit. Very important thing to keep in mind, too, is that under your construction contract, there are provisions that provide the contractor will indemnify the owner against the liabilities that come from its own misconduct, its own fault. Under the normal form of insurance policy, these indemnification payments are covered by the insurance. They're actually normally obligations that you undertake by a contract, such as an indemnity contract, are not covered by insurance because we're not here to stand behind your contract, but an insured contract, a construction contract that promises that the contractor will indemnify the owner for the contractor's mistakes. That's an insured contract, and it is covered by the insurance. And here's where the trick comes in, because if the payment is being made purely because of indemnification, then the legal expenses and other expenses, other supplemental expenses like investigations and doctors and such, are deemed to be inside the limit. So because an indemnification claim has been added to the whole situation, many insurance companies sit there, keep track of legal expenses, and when they hit the $1 million, say, "We're done. Used up the insurance." But just because the insurance company makes that claim doesn't mean they're right. In fact, the law in almost all states, there are a few exceptions still, is this: if the indemnification claim being made against the contractor is also tied to something that would have given rise to liability, even if there weren't an indemnity agreement, then we have to defend the contractor, and now all the costs of defense are outside the limit. But the insurance companies will still come in, and actually come in on the morning of trial and claim the insurance has been exhausted because of expenses, and they abandon the insured to its own devices. And a lot of people will look at that and realize they've been sold down the river, and they might as well settle the case what they can and hope for the best. But in fact, the insurance company is still, if and think it through, like if it describes to you, your insurance company is still on the hook. They're still going to pay. You may have to write a check to your lawyer in the first instance, but down the road they're going to have to reimburse you because they did not have the right to claim exhaustion because, again, those costs and expenses were outside the limit. They did not exhaust those liability because, again, in indemnity, they would have had to pay for the claim anyway. If, in fact, their own client did not have liability except because of the indemnity, that's different. Totally different. If their client was totally free from fault and still gets called upon to make an indemnity, then the insurance company is within its rights in pulling back and saying, not for this one. For this one, the defense costs are inside the limit, and you're using up your insurance by paying, laying up to the lawyers, and that's just the way it is. But never take the first reaction of an insurance company, right? Because there are ways to get around it. Now, talking about elements of insurance also, when you buy your insurance, you can have certain options for the aggregate insurance. Particularly, you can have the aggregate applied per policy or per project. Here's the idea. You're a developer. You hire a contractor to go and do work for you, and you insist that he has to have $5 million of insurance. And you make sure that the aggregate is not going to be used up by the customary project he has around the corner. So you have the policy to apply per project. Now, there's a separate $5 million aggregate that applies just to your project. And there's a price you pay for it. But a whole lot less than someone discovering that your contractor doesn't have insurance because of a claim around the block that wiped out his insurance. Especially going when you consider part of what you're paying your contractor includes insurance costs. So you're paying for the insurance, and it doesn't come in because not something you did, but something that some other bozo did down the street, had nothing to do with your project. And if your policy is written with per policy limits, you lose. But if you had it written per project or per location, your $5 million aggregate would still be in place. Now, talking about insurance, if you ask a lawyer in liability insurance, how much insurance did you buy? The lawyer will typically say, how high is up? You need to work with your risk managers and people to decide the amounts. But it may come out and you say, with the work we're in, it's possible, it's happened, that people have hit the insurance for $100 billion. And you turn the insurance company and they smile and say, the premium that will be, and they show you a number, and you turn green and say, can't do it. What you can do is you can break your insurance up into chunks, layers. So you have a primary layer that pays for the first $1 million. When that's used up, an excess layer pops into place and says, pays the next 5, 10, 50, whatever. The numbers you work out have to do with how you structure your premiums and you negotiate. But the point is, by breaking these things down, most claims won't penetrate the excess layers. So the cost per $1 million of excess insurance is much less than primary insurance. Now, in addition, there's a kind of insurance called umbrella. Keep on your toes because there are a lot of policies out there that are described as being umbrella policies, but when you look at them, they're just a pure excess policy. What am I talking about? Under a pure excess policy, you buy an insurance policy that covers you for X, Y, and Z, and you use up that insurance. Now, the excess policy comes into place. If it wasn't covered under the primary policy, it ain't covered under the excess. That's what we say, it's pure excess or follow form policy. It tacks on, and it adopts the coverage of the lower layers. And that's all you have. If the claim is outside of that, if the claim comes in that alleges that, asbestos, classic example. If a person comes in and claims he was injured by asbestos, and he developed asbestosis or mesothelioma for 30 years, but he was such a tremendous dosage of asbestos dumped on him that he's suing. Right? Your insurance almost certainly excludes this from coverage. However, you can obtain what's called umbrella policies. And an umbrella policy, like an umbrella, it opens up wide. So it actually covers things that were not covered by the primary policy. Now, it may not cover them well. All these policies come with a deductible amount, or sometimes a self-insured retainage. There's an amount that you have to absorb first before the insurance company is responsible to take the losses. In the case of an umbrella, you typically have a much bigger deductible. For example, I have a policy written, the umbrella policy written to be $100 million excess of the first $1 million that covers the same thing as the first $1 million and also covers these are some claims. However, when a claim comes in under the umbrella, there is typically a bigger deductible. And bigger, I mean, I've seen policies written that say basically the deductible is $1 million. So you absorb the first $1 million of loss, and we'll cover the rest. Others will still have a larger deductible for the umbrella coverage without really, ripping your arm off and saying, normally the deductible for this coverage is $10,000. This is an umbrella claim. The deductible is $50,000, but we'll still cover you after $50,000 is paid. We'll cover the excess. And you have to read the policy. The mantra, by the way, is RTFT. Read the friendly policy. Until you read the policy, you don't know what you have. And it's all written down. It's just look what's there. Now, as a layperson, without special training, you may not understand what's going on. And ask questions. Classic example. There are liability policies out there to be written with something called a classification limitation endorsement. And a lot of people will insist to you that no, nobody writes this insurance. I mean, I raised this at a conference some years ago, and I was attacked roundly that I didn't know what I was talking about, that was no longer being used. And, of course, the insurance companies were lying in their teeth. A classification limitation endorsement says that this liability insurance applies only to the risks and projects that are specifically scheduled in the policy. So if your contractor is doing work at 123 Main Street and the policy doesn't say he's covered for 123 Main Street, he has no insurance. And I've seen dozens of projects blow up about this very clause. The same thing the insurance companies insist we don't do that. In fact, they do. There's no substitute for looking at the policy itself and understanding it. Ask questions. If you ask questions, they have to answer you. They have to answer you honestly. Just answer questions and document it. Now, we were talking before about the fact that you as an owner will ask the contractor to make you an additional insured on his policy. Additional insured coverage is one of the most frequent causes of lawsuits. This happens because, in many cases it turns out you think you're additional insured. You even have a certificate of insurance that says you're an additional insured, and in fact you're not. In order to be an additional insured under a policy, the policy has to be endorsed. Endorsement means there's a piece of paper called endorsement. The modification, it's a rider. It has to be attached to the contract, attached to the policy, and it says that you are an additional insured on the policy. Now, if that's where it ends, that's a good thing, because that means you have all the same rights as the named insured on the policy. However, about half the companies in this country don't stop at that point. They then add more stuff, and it's not good for you. It will typically say, however, we are not responsible to cover you as an insured if the sole fault of the accident was yours. Or we will not cover you unless your liability for the acts of the additional insured are in the nature of vicarious liability, which is a joke. Vicarious liability is the kind of liability that an employer has for an employee. So if you send your employee out on a car to go get stuff from the store, and he plows into a school bus full of children, he's on a trip for you. He's on his employer's business. The employer is vicariously liable. You're liable as if you were driving the car, because the law requires it. Now, if the policy, the contract said nothing at all about this, you would still be entitled by law to indemnification from the employee and his insurance for the loss you caused, because your liability is purely vicarious. You did nothing wrong except perhaps hiring a person who doesn't know how to drive very well. The point is, you did not cause the accident. Your employee caused it, so your liability is vicarious only, and you're entitled to indemnity. If the insurance policy is limited to vicarious liability, then it does nothing. Because, remember, the employee is liable to indemnify you for the loss. It's covered by his insurance. You don't need to be additional insured in order to get that coverage. So what we say is it's an illusion. It's a mirage. It's worthless. Now, while on the topic of these certificates of insurance are a recurring issue because everybody takes them. You look at these policies, you look at these contracts, and of course, call for contractors and subcontractors and engineers to file a certificate of insurance. And that means in this world, the big form published by the Accord Corporation called an Accord 25 proof of insurance. But it says in the upper right-hand corner, this certificate is issued as a matter of information only. It does not extend, change, or modify the rights and obligations of the parties to the insurance policy. What it says essentially in the right-hand corner is, hello, I am a worthless piece of paper. Use me at your peril. Look at the insurance policy because that's where your rights are coming from. Even if you could rely on an insurance certificate, it provides so little information that it's next to useless. Next to useless. So you always see the insurance policy itself. That's what determines your rights. And you'd be surprised at the mistakes you'll discover when you review the policy. I have reviewed policies produced by the leading lights of the insurance industry, the biggest producers, the biggest brokers in the world, and they still make mistakes. They name the parties incorrectly. They name the project incorrectly. They forget to name the owner as initial insured, and that's just the tip of the iceberg. It's very important to keep an eye on what's going on in that area. In construction also, you want to make certainly sure that your contractors all have workers' compensation insurance and employer's liability. It can be a great boon, especially in states like New York, where this layer of insurance is written with no limit of liability, an infinite limit. Whatever it takes to cover liability, the insurance company has to pay out. Of course, that's why this insurance is so blessed expensive in New York. It's outrageously expensive, but it's great coverage. It pays without a limit.
New York has no limit on the policy? There's not a limit on the employer's liability?
Employer's liability is considered to be a species of workers' compensation. And like workers' compensation, the policies are written without limit. That's New York. Other states are sensible. Other states aren't insane. They actually have limits of liability. I mean, they'd be very large limits of liability, but at least there's some limit out there. No, not in New York. I have seen people who had horrible injuries. I had one fellow, frankly, who had a tower crane fall on him, and he survived. The insurance company is paying him to date over $5 million, and they're still paying. As long as he lives, he's going to still being paid for pain and suffering and disability. That's the way it is. Another area you want to, if your contractors don't have insurance and you're the owner of the project, then some of the mess is going to end up in your lap because the owner is legally responsible in almost all states for providing the workers with a safe place to work, a safe place to stand, and a safe, secure place to do their work without things falling on them or crushing them or otherwise making the situation unsafe. So you have this exposure. If your contractors have the right kind of workers' compensation, employer's liability coverage, those policies will absorb the whole loss and it will never reach you. Of course, subrogation again, you also want to make darn tootin' sure that the workers' compensation insurance company has waived its right to sue people for these losses, because otherwise, since there may be no limit of liability here, again, you have an open-ended disaster on your hands, but it can be controlled. It can be controlled through the contract. And the contract is an essential tool for risk management, and it's important to keep in mind. We're talking about insurance, but insurance is simply one aspect of the larger topic of risk management. In risk management, we sit down, we identify where are the ways we can get hurt. And then we ask ourselves, well, which things should we get insurance for? And which things should we control in other ways? As, for example, by running a contract clause that says, this is not our responsibility. Right? If these things happen here, you, a contractor, you deal with it. Okay? You bring a tower crane on the project. You get the insurance for that tower crane, not us. No matter what happens, if the tower crane gets destroyed, it's not going to affect our bottom line. And of course, it may delay the project, but we're not going to pay for the tower crane because it's on your head. And any number of other things. Tools, hand tools on the project. I've seen situations where contractors have put in claims for hundreds of thousands of dollars for hand tools, shovels, saws, picks, you name it, that disappeared from the site. It's part of the cost of doing business, and it's cost plus contract, therefore insane. Those things should be covered by the contractor's insurance. Do it that way, leave it up to the owner's bottom line. The bottom line comes down to one of coordination. The contract is the place where you can provide for insurance, and you can allocate and share risks. And it has to be read together with the insurance. If you don't coordinate the contract with the insurance, then you may end up reaping only the liveliest awfulness. And that's the important thing to keep in mind. The insurance is there to protect you. And keep in mind that the insurance companies will, because they're required by law or by profit motive, fight every claim to the extent it's appropriate to do so. So if the insurance isn't written in a way to respond to a risk, you can't expect the insurance company to pay for it. If there's a fire that destroys a load of timber when it's laid down on site next door, and it's 2,000 feet away from the site, the insurance company might not pay for it. They certainly aren't obligated to pay for it because it's outside the zone of danger. It's not covered. I mean, some companies will pay it because they realize that if they don't pay this claim, they're going to lose the relationship with the insured. And in fact, it's a profitable relationship, so they'll take that chance. But within the four corners of the insurance contract, they don't have an obligation to pay. The time to make sure that the obligation to pay is understood and in the policy and reflect the contract is before a loss takes place. Once there's been a loss, once there's been a casualty, it's too late to go back and say, oops, we meant to cover this, but too bad, too late. That's the way it works. And
the insurance.
Bottom line is, a lot of those you can talk about, but this is where we are for today.
Right. Well, Kevin, I'm just looking on the clock here, and I hate to say it, but just about out of time here. And I wanted to first thank you for taking some time to talk a little bit about construction law. And definitely, even being in the business, it's always good to hear somebody talk about it that knows what they're talking about and sees it as clearly as you do. So I appreciate that. Is there anything you'd like to say before we go? Is there a good way for people to get a hold of you if they'd like to reach out to you? What's the best way to reach out?
Unfortunately, the best way to find me is either through my email address, which is easy enough. It's kjconnollyesq@yahoo.com. You can also check me out on LinkedIn, where I have a page that details my history and what I do. Certainly, if you contact me through that, I'll respond quickly. I'm more than happy to help you with looking at your insurance situation. And God forbid, if you have a claim, I can help you with that too. But ideally, I prevent you from making claims in the first place. And that's where I'm making reputation to avoid claims, get paid, get your project built.
Got it. Well, Kevin, again, I've enjoyed talking with you, and hopefully we can do it again. For the listeners, if you like what we're doing, please let us know. Tell your friends, colleagues, network. And remember, you can find us by searching Commercial Real Estate Pro Network. And also you can find us on Facebook, YouTube, LinkedIn, and Twitter at CRE Pro Network. And soon, commercialrealestatepronetwork.com. Until next time, thanks for listening to Commercial Real Estate Pro Network, CREPN Radio.
You're listening to CREPN Radio for influential commercial real estate professionals. For more information on this or any of our guests, like us on Facebook, CREPN Radio.